appeal in the matter of Commissioner for His Ministry of Illegal Custom and VolkerRail Plant Ltd.
Yes. Good morning, my ladies, my lord. I appear on behalf of the taxpayers in this matter, together with my learned junior, Ms. Kelly Strickland-Coutinho, my learned friends, Mr. David Hewitt KC, Mr. Mark Fell KC, and Mr. Harry Winter appear on behalf of the Revenue. And before we get going, in light of the flurry of emails yesterday, can I just check that you have the two bundles in the format that you prefer? I, myself, and I believe Mr. Hewitt, we're both stuck in the dark ages, and we're going to be referring to the hard copy bundle. So, but if you need another reference, please do let me know.
That's a relief for me, if not for my colleagues.
And for me as well.
Can I please start by handing up a list of issues and a timetable which we've agreed between us?
That covers the first question I was going to ask you, actually, which was have you discussed between you what you're going to do? So that's excellent. Thank you. But while we're waiting for that, there were, I think, 3 documents that might be helpful. The first one is the statement of agreed facts that was before the FTT in the bundle anywhere?
I think it was reproduced verbatim in the FTT decision.
Oh, I see. So the whole thing is in the FTT
but
decision.
if perhaps I can just double check that.
Yes.
I can provide you with a copy at lunchtime or something like that.
And the other thing that's been mentioned in our discussions is the closure notices, which are the source of the appeal. Are they anywhere in the bundle?
They're not in the bundle. Again, we can provide you with those if you would find that helpful.
And then there's a comparative analysis, which is referred to in paragraph 11 of HMRC's appeal skeleton. So
again, that's not in the bundle, but I'm sure that
could
the
we
Revenue
also be provided with that?
pull it out. Yeah.
Brilliant. Thank you. All right, I'll stop interrupting you.
No, not at all. So you can see from the list of issues that we've identified 5 issues. Broadly speaking, the first 3 issues are the taxpayer's appeal, and the last 2 issues, 4 and 5, are the revenue cross appeal. Now, the umbrella issue to which these appeals give rise is whether Section 403D1C, which restricts the availability of group relief in respect of non-resident companies, is compatible with the freedom of establishment. And that was, of course, the very issue which was referred to the Court of Justice in Philips Electronics, and which decided that Section 403D1C was not compatible with the freedom of establishment. And the questions for determination in these appeals essentially centre on whether Philips should be taken to have been superseded by the subsequent case of NN, or if it cannot, whether this court should use its powers under Section 6 of the EU Withdrawal Act and depart from it. So can we please start by turning up the provision, which is in Volume A of the Authorities, behind tab 13. It's page 56.
Sorry, inevitably I've got a bundle which is falling to pieces.
Is the ring binder broken?
Yes.
My lord, it has.
So I mean, it's okay. I'll get there in a minute. It's just if at some point, perhaps a fresh binder would be provided.
Yes.
I would be very grateful.
Yeah, no problem.
Sorry, the page reference again.
The page is 56.
56. Thank you very much.
Yeah, we'll just...
Thank you very much. Thank you.
I think what you've You've been had as being printed on double side.
Oh, that's
so
why
I hope
still
that's okay.
Yeah, absolutely, yes.
At least it works.
56, got
56,
that. Yes.
yeah.
Sorry,
So we can see here that the provision applies in determining the amounts for any accounting period of the losses and other amounts available for surrender by way of group relief by a non-resident company carrying on a trade in the UK through a permanent establishment. No loss or other amount shall be treated as so available, except in so far as, and it's C, no part of the loss or other amount corresponds to or is represented in any amount which, for the purposes of any foreign tax, is in any period deductible from or otherwise allowable from against non-UK profits of the company or any other person. So there are 4 points to note about this provision. The first is that the provision restricts the surrender by way of group relief of UK losses to other companies within the group. So we're not here concerned with group relief in respect of foreign losses. This isn't a cross-border losses case, it's a UK domestic losses case. The second point to note is that there is no equivalent restriction, there's no equivalent provision applicable to losses incurred by a UK company. The third point is that the surrender, what section 403D1C prohibits, is the surrender of any losses if only part of those losses is deductible against non-UK profits. And the fourth point is that the restriction only applies as far as group relief of losses is concerned. There is no equivalent restriction on a permanent establishment carrying forward its losses or carrying back its losses. And I don't think we need to turn up those provisions because that's not a point in dispute. But for your note, those provisions are behind tabs 9 and 10, and they're sections 393 and 393A of ICTA. So that was the legislation applicable during the relevant accounting periods. So in this case, we're concerned with accounting periods ending December 2007, 2008 and 2009. And then what happened was section...
Sorry, Ms. Shaw, can I just interrupt on the second of those, no equivalent provision in relation to losses of a UK company? There were provisions, I think they're not in the bundle, in relation to companies that were dual resident, prohibiting surrenders of losses. So, in other words, companies that were resident in more than one place,
right.
There were restrictions on surrenders of losses in relation to those, which there's some comparability in the sense that in that situation as well, you've got a company that's potentially within the scope of two tax authorities' taxing systems.
I'm afraid I can't help you.
I think it was section 404, but
I can't help you on that. I mean, certainly, as far as, I mean, we'll come on to look at Phillips and in a moment, but as far as Phillips was concerned, the analysis was very much rooted in the absence of an equivalent condition for UK companies, whether there was, if you like, a carve-out for UK companies that happen to be dual resident is not something that was explored by the court, and in our submission is not a complete answer.
I appreciate that it wasn't explored in Phillips. I'm merely making the point of what the domestic system actually provided.
Absolutely. But the general point remains: there is not under these provisions an equivalent condition for UK resident companies as such, and it's certainly it's not in dispute that it was, at least in some instances, possible for a UK subsidiary of a non-resident company's losses to be used in another member state. So the comparative analysis that you've asked to see, that was produced by the Revenue, and my recollection is it showed that in 4 instances there was a possibility of a UK subs losses being utilised in another member state. So that's approximately 15% of the EU. So it's not that it could never take place. There was some possibility, and that in our submission is the thrust of the reasoning in Phillips. So then what happened was Section 403D was rewritten to Section 107 of the Corporation Tax Act 2010, and we don't need to turn that up. That's behind tab 19. But could we please turn up tab 20, page 70, which is the amended Section 107. And this provision, as you can see from the top of the page, applied with effect from the 1st of April 2013. And so in Section 107, it's Section 107(1)A that sets out the conditions for EU companies with a UK PE. And it's subsection 6A that we're interested in, which is over the page 71. And that provides that a loss or other amount may not be surrendered if and to the extent that it or any amount brought into account in calculating it corresponds to or is represented in amounts within subsection 6B. And 6B is an amount is within the subsection if for the purposes of non-UK tax chargeable under the law of a territory, the amount is in any period deducted from or otherwise allowed against non-UK profits of any person. So following the decision in Phillips, and that's what prompted the amendment of Section 107, Parliament replaced the test of deductibility with a test of actual deduction. And in our submission, that is a conceptually different test. So Section 107, as amended, is not, should not be taken to be modifying the existing test. In our submission, it is replacing it with a test of an altogether different nature. And apropos of that, can we please turn up in the hearing bundle towards the back? We have correspondence between the Commission and the UK, an anonymous complainant. If we start with tab 21, page 281. This is the Commission's letter to the UK. And over the page you can see there it sets out the amended Section 107. And under the heading 2, effectively aforementioned provisions, you can see that it accepts that it restricts the use of UK PAP losses, which are actually deducted from or otherwise allowed against non-UK profits of any person. And then over the page it sets out why the Commission considers that amended legislation is not compatible with the freedom of establishment. And then behind tab 20 is the UK's response. So page 274. And if we pick it up on page 276, in paragraph 13 there, the UK say, the rule examined in Phillips was amended by Section 30 of the Finance Act 2013. So that the choice of secondary establishment in the UK by companies having their seat in other member states is no longer restricted. The possibility test has been removed and replaced with an actual use test. So in our submission, that is the UK acknowledging that the amendment of Section 107 amounted to the removal of the old test and its replacement with a new test, which had the effect of removing the restriction. So, and then for completeness, behind tab 19, page 272, we've got the Commission's letter to whoever the complainant was, and you can see there they set out the dispositif from the decision in NN, and then over the page they say it appears that the Danish legislation, which was analysed by the court in the NN case, is less beneficial for the taxpayers than the UK legislation for which you complained. Nevertheless, that less favourable legislation was found to be in line with the right of establishment by the court. Now, as we'll see in a moment, the Danish legislation operated by reference to a no possibilities test, whereas the amended UK legislation, as we've seen, operated by reference to an actual deduction test. So that's why the Commission considered that the legislation in the Danish, in NN, was less beneficial. And then it continues the penultimate paragraph. The Commission services consider that an infringement of EU law is unlikely to be proven before the Court of Justice, insofar as the UK legislation at stake excludes the relief only for the amounts of losses which were actually deducted from or otherwise allowed against non-UK profits of any person, and notify then the claimant that the complaint is closed. So, turning then to Phillips, which is in the Authorities, Volume 3, it's tab 58.
Tab 57.
Yeah, sorry, you're quite right, it's tab 57. Starts on page 678. That's the
It depends
that's
whether
the
you want
AG.
us to look at the AG or the
Yes,
court.
thank you. Sorry, the judgment. If we can start with the judgment, which is tab 58, page 697. And we can pick it up, please, in paragraph 11 on page 700. Do you have that?
Yes.
So paragraph 11, the court says, by its first question, the referring court seeks in essence to ascertain whether Article 43, the freedom of establishment, must be interpreted as meaning that where the possibility of transferring by means of group relief and to a resident company, losses sustained by the PE in that member state of a non-resident company are subject to a condition that those losses cannot be used for the purposes of foreign taxation, and where the transfer of losses sustained in that member state by a resident company is not subject to any equivalent condition, such provisions constitute a restriction on the freedom of a non-resident company to establish itself in another member state. Now, in our submission, the absence of an equivalent restriction on UK companies is absolutely central to the court's analysis in Phillips. It is the premise on which the question is based, and it is the premise on which the question is answered. And you'll see further references to that feature in paragraphs 15, 20, 27, and 29 of the judgment. So in our submission, it is not tenable to suggest that the absence of an equivalent condition was not of central importance to the court's reasoning in Phillips. And the reason why it is of central importance to the court's reasoning in Phillips is because, as the court explains in paragraph 16, the absence of an equivalent restriction on UK companies produces a difference of treatment which makes it less attractive for companies having their seat in other member states to exercise the right to freedom of establishment through a branch. It follows that national legislation such as that at issue in the main proceedings restricts the freedom to choose the appropriate legal form in which to pursue activities in another member state. So the freedom of establishment at issue in Phillips is that of a non-resident company wishing to establish itself in the UK. And in that situation, the UK is the host state as opposed to the state of origin or the home state. And again, we say that factor, the UK's status as host state, is highly material to the court's analysis in Phillips, as demonstrated from the fact that the court uses the term host state to describe the UK on 6 separate occasions between paragraphs 25 and 33. So then, in paragraph 17 of the judgment, the court explains that in order for that difference, in other words, the difference in treatment between a non-resident company with a UK PE and a UK company, in order for that difference to be compatible with the freedom of establishment, it must either relate to situations which are not objectively comparable, or it must be justified by overriding reasons in the public interest. So the court addresses the first of those, objective comparability, quite briefly in paragraphs 18 and 19. So in paragraph 18, it records the UK's submission that a non-resident company with only a UK PE is not comparable to a UK company, because whereas a UK PE is taxed on its UK activities, a UK company is taxed on its worldwide activities. And then in 19 it says, such an analysis cannot, however, be accepted. The situation of a non-resident company with only a permanent establishment in the national territory and that of a resident company are, having regard to the objective of a tax regime such as that at issue in the main proceedings, objectively comparable insofar as concerns the possibility of transferring by means of group relief losses sustained in the United Kingdom to another company in that group. Now, in our submission, what the court means by having regard to the objective of the tax regime such as that at issue in the main proceedings is that where the objective of the tax system is to treat a UK PE of a non-resident company in the same way as a UK company as regards the taxation of profits generated in the UK, and indeed where a UK PE of a non-resident company and a UK company are treated in every other regard within that tax regime in the same way, then such entities must be regarded as objectively comparable for the purposes of group relief, which after all concerns the surrender of UK losses to other UK entities within the group. So that is what we say the court is rather pithily encapsulating in paragraph 19 there. And that is essentially the same point which the AG makes in her opinion in paragraphs 34 to 37. So if you can possibly just turn that up. It's page 688 behind tab 57. So in 34, she says, the court has ruled on several occasions that a resident company with a non-resident and a non-resident company which operates domestically through a PE may be in a comparable situation with regard to their domestic taxation. In RBS in Greece, the court held that such companies were in an objectively comparable situation, since the basis for assessment for corporation tax was calculated in the same way for both companies. Accordingly, it was unimportant in the view of the court that resident companies were taxed on the basis of their worldwide income and non-resident companies only on the basis of their income generated domestically. Such differences with regard to the member states' power of taxation, highlighted by the United Kingdom government, are therefore significant not in connection with the objective comparability of the situations, but at best in examining justifications. And then she says in the St. Gobain case, the court also recognised a comparable situation of resident and non-resident companies, primarily because the difference in treatment applied only as regards the grant of the tax concessions in question. In the present case, the lower court in the main proceedings found in this regard that domestic companies and UK resident PEs of foreign companies are treated in exactly the same way for the purposes of corporation tax with regard to the profits and losses made in the UK, with the exception of the group relief, which is at issue here. A restriction of the freedom of establishment cannot therefore be rejected on the ground that a domestic company and a foreign company with the UK branch are not in an objectively comparable situation as regards their taxation. Thus, foreign companies are permitted in relation to their PEs, in particular, to transfer losses to earlier or subsequent tax periods in the same way as domestic companies. UK law clearly, therefore, regards the situations as essentially comparable with regard to losses. So, in other words, when profits are taxable in the same way and in every other respect, the UK treats PEs of non-resident companies in the same way as UK companies, then the UK must be taken to have accepted that those two situations are comparable.
But that seems to leave out of account the point that the AG recalls in paragraph 31, which was made by the UK government, which is about what income comes into the calculation.
Yeah, I mean, essentially what she's saying there is that the court's already held that is not a relevant distinction. As far as UK activities are concerned, profits and losses are treated in the same way.
I mean, to a non-specialist, that seems a slightly odd approach, but anyway.
Well, I think what they're saying is that the tax regime is concerned with activities taking place on the territory, and as regards those activities, it's the same. It's the same basis of assessment.
So you, as I understand it, you're identifying the objective of the tax regime as referred to by the court at para 19 as encompassing everything that you've just described.
Yes.
Rather than allowing a more nuanced approach to an objective of the tax regime that might, for example, try to address perceived concern about double use of losses.
Yes, I mean, it does depend what you mean by the tax regime. You could take a very wide view of the tax regime. You could just say it's everything that's in the UK tax code, or you could take a narrower view and say, well, it's everything to do with how groups are taxed in the UK, or you could take the narrowest possible view, which is you're just looking at section 403D1C.
Yeah, no, I'm just trying to understand your point is broader than that, definitely broader than that, because you're saying look at how branches are generally, permanent establishments are generally taxed, they're generally comparable to the tax treatment of UK companies.
Yeah.
And you say we should read that passage in the judgment of the court with the opinion, or the paragraphs of the opinion.
Yeah, absolutely. And this is something which the court keeps coming back to. It's looking for a link between the losses and the profits. And that's why there is this distinction between a host state and a home state, because a host state, the losses are domestic losses generated in the UK, and the utilisation of those losses in the UK is linked to the UK's right to tax the profits, any profits that arise. And so that's the tax regime that it's referring to there, is the treatment of profits and losses in a UK PE of a non-resident company versus the profits and losses in a UK company. So I was going to move on then to the second question. So we're back on page 702, behind tab 58. And the second question is whether that restriction is justified. So that the question is whether the restriction on the freedom of a non-resident company to establish itself in the UK can be justified by any overriding reasons in the public interest. So in paragraph 25, the court rejects the balanced allocation of taxing rights as a justification in a host state case because the UK's right to tax UK profits is entirely unaffected by the group relief of UK losses to another UK entity. And then in paragraph 26, the court distinguishes that situation from a situation involving foreign losses, where the relationship between the taxation of profits and the utilisation of losses lacks the requisite symmetry. And then in 27, the court says this: it follows that the host member state on whose territory the economic activity giving rise to the losses of the PE is carried out cannot, in a situation such as that at issue in the main proceedings, use the objective of a situation such as that at issue in the main proceedings use the objective of preserving the allocation of the power to impose taxes between the member states as a justification for the fact that under its national legislation, the possibility of transferring by means of group relief to a resident company losses sustained by the PE in that member state of a non-resident company is subject to a condition that those losses cannot be used for the purposes of foreign taxation, while the transfer of losses sustained in that member state by a resident company is not subject to any equivalent condition. So we say that its reasoning here is explicitly tied to the status of the UK as a host state and the absence of an equivalent restriction on UK companies. So then the court moves on to consider the objective of preventing the double use of losses. And it says in 28 that even if such a ground, considered independently, could be relied on, it cannot in any event be relied on in the circumstances such as those in the main proceedings to justify the national legislation of the host member state. And it continues, the dispute in the main proceedings concerns the question whether the host member state may impose certain conditions on the possibility of transferring through group relief and to a resident company losses sustained by the PE situated in that member state of a non-resident company, while the transfer of losses sustained in that member state by a resident company is not subject to any equivalent condition. So again, the court's reasoning in this regard in relation to the double use of losses is once again tied explicitly to the UK's status as host state and the absence of an equivalent restriction on UK companies. And then in 30, the court explains that in such circumstances, the use of the losses in both the host state and the member state in which the non-resident company is based does not impact upon the UK's right to tax UK profits. And then it says in 31, as observed by the AG in point 49 et sec of her opinion, the losses transferred by the PE in the UK of LGPD Netherlands to Philips Electronics UK, which is a resident company established in the UK, can be linked in any event to the UK's power to impose taxes. That power is not at all impaired by the fact that the losses transferred might also, in appropriate circumstances, be used in the Netherlands. So in other words, the point that I made a moment ago, the UK losses, the domestic losses in issue, are linked to the UK's power to tax the UK PE on any UK profits. And even if those losses are deducted in the Netherlands, that has no impact on the UK's right to tax.
But I mean, doesn't that rather prompt the question, well, isn't that rather missing the whole point? I mean, the problem is the double deduction, isn't it? I mean, from an economic and policy point of view.
Well, you're leaping many
I know,
leagues into the future there.
Yes.
But we would say not. I mean, this is essentially the difference between us. The revenue saying, well, why should they get this unjustified, unfair tax advantage? And we say that's the wrong way of looking at this. The question, you scoff, but the question which
I'm not scoffing.
which the court is asking in Philips is why should the UK, as the host state, be permitted to discriminate? That's the question. The reason why we're in this predicament is because the UK has failed to comply with its community law obligations. If the UK had implemented an equivalent restriction on UK companies, I wouldn't be here. So the question is not why should we get this unfair tax advantage. The question is why should the UK be allowed to discriminate? The fact that the consequence of their discrimination is that we get that deduction is not a basis on which to simply say, well, we can't let that happen. We're going to forgive the UK's discrimination. The answer is the UK needs to get its books in order. The UK needs to right its wrong. It's not for this court to say, well, that's an objectionable outcome. That outcome is only generated by the UK's failures. So that, in my respectful submission, is the question you need to ask yourself, is why should the UK be allowed to discriminate? And the court in Philips is absolutely clear. It's not allowed to discriminate because it is the host. So then in 32, the court says, consequently, in circumstances such as those of the main proceedings, the objective of preventing the risk of double use of losses cannot, as such, allow the member state in which the PE is situated to exclude the use of losses on the ground that those losses may also be used in the member state in which the non-resident company has its seat. The host state in whose territory the PE is situated therefore cannot, in order to justify its legislation in a situation such as that in the main proceedings, and in any event, plead as an independent justification the risk of the double use of losses. So in other words, in a host state case such as this, the risk of the double deduction of losses isn't a justification for infringing the freedom of establishment of a non-resident company. So if we can turn up 49 et sec of the AGO, which begins on 691, and in our submission, when the court endorses 49 et sec of the AGO, it can and should properly be taken to have endorsed 49 through to 67 of the AGO. And we say that because in the first place, the court's endorsement of the AGO is in the context of its discussion of the justification of the double deduction of losses. So it's reasonable to assume that it agreed with the part of her opinion which expressly addressed that topic. And secondly, as we'll see, the AG's reasoning in relation to the two objectives, the balanced allocation of taxing powers and the double deduction of losses, is intertwined, and as indeed are the court's conclusions. And so in our submission, it's not realistic to suggest, as the Upper Tribunal tried to do, that the court's endorsement of her opinion was more limited. So in paragraph 50, she explains that the balanced allocation of taxing powers is only impaired if losses which are incurred within the scope of the exclusive power of taxation of another member state are taken into account, in other words, foreign losses. Such losses would reduce the tax revenue of the UK, even though the profits from the activity cannot be taxed. Accordingly, the court has examined the need to prevent the double use of losses almost exclusively in cases where a member state refused to take into account losses incurred in another member state. And then she refers in the footnote there to Marks and Spencer and Lidl, Belgium, and those were both instances where the member state in question was the home state and the losses in issue were foreign losses. And then she says, on the single occasion so far when domestic losses were at issue, in Papillon, the court rejected reliance on the objective of preventing the double use of losses on the ground that losses recorded in one and the same member state were being taken into account. So then in 52, she goes on to explain that the balanced allocation of taxing rights is not an issue where the activities of the UKPE are subject to tax, because in that scenario you have symmetry between profits and losses. And then in 53, she addresses the UK's submission that when it comes to assessing the balanced allocation of taxing rights, you have to have regard to the fact that UK PEs of non-resident companies and UK companies are not taxed in the same way. Your point, my lady, that a UK PE is only taxed on UK activities, whereas a UK company is taxed on its worldwide activities. And she says this in 54, in X holding, the court ruled with regard to the justification of the allocation of the power of taxation that from the perspective of a company's state of origin, its PE situated in another member state and its non-resident subsidiaries are not in a comparable situation. The subsidiary is subject to unlimited tax liability in the other member state, whilst the PE remains in principle and in part subject to the fiscal jurisdiction of the member state of origin. So in other words, from the home state's perspective, permanent establishment, non-resident permanent establishments and non-resident subsidiaries are not comparable from the home state's perspective. And she goes on, however, as I explained in my opinion in Ex Holding, there are different duties for the member state of origin and the host member state with regard to the allocation of the power to impose taxes. The member state of origin may treat the foreign permanent establishments and subsidiaries of a domestic company differently. It enjoys a generally subordinate right of taxation only with regard to the foreign permanent establishments, but not with regard to foreign subsidiaries. The situation is different, however, for the host member state. As a rule, it has the right to tax with regard to both types of establishment. The host member state must also therefore treat both those types of establishment of a company established in another member state equally in levying tax. So in other words, a host state is not entitled to discriminate between PEs established in that state of a non-resident company and companies established in that host member state. And that is because it enjoys taxing rights over both. And she says, on these grounds, the UK, as the host member state, cannot rely on the justification of preserving the allocation of the power of taxation, where it refuses group relief under certain conditions for UK resident branches, in contrast with domestic companies. So, in other words, whether or not a member state is entitled to discriminate between a PE and a company depends on its status, it depends on its point of view. If it's the home state, it can. If it's the host state, it can't. And she then moves on in the next section to consider the double use of losses. And she starts in 60 and 61 by acknowledging that it's entirely a matter for each member state whether it allows a resident company to deduct the losses of any non-resident PEs. So there's no requirement to allow those losses, but equally, if you do allow those losses, there can be no complaint. And then she says this in 62. If the member state in which the company is established nevertheless takes into account the losses of the foreign PE, there is an at least temporary double use of the losses of a foreign PE. In such a case, however, it is not clear why the member state in which the PE is situated should have the power to rule out the use of the losses on the ground that they are already taken into account in the member state in which the company is established. As we have seen, the power of taxation of the member state in which the PE is situated is not affected. Its tax revenue is the same, irrespective of whether losses of the PE are also taken into account in the company's home state. So in other words, the host state is not permitted to discriminate on that basis because the deduction of UK losses elsewhere within the EU does not impact upon the UK's right to tax the UK activities of that PE. And then in 66, she says this, that even if the prevention of the double use of losses were to be recognised as an autonomous justification, the tax rules in the UK would not in any case be capable of preventing double use. As the court has pointed out, national legislation is appropriate for ensuring attainment of the objective pursued only if it genuinely reflects a concern to attain it in a consistent and systematic manner. This is clearly not the case in the UK with regard to the double use of losses of UK PEs of foreign companies. Condition in section 403D1C applies only to group relief. However, carrying losses forward and back over different tax periods is permitted for PEs situated in the UK, irrespective of whether such losses are also taken into account in the company's member state. Tax rules on deduction of losses do not, therefore, on the whole, pursue in a consistent manner the objective of preventing the double use of losses. She says even if it is an autonomous justification, it wouldn't apply in this particular case because the UK does not pursue that objective consistently. And in our submission, when the court endorses Paras 49 et sec of the AGO, it should be treated as having endorsed all of that reasoning because the golden thread running through Paras 49 et sec is that a host state is not entitled to discriminate as between a resident company and a resident PE of a non-resident company because it enjoys equivalent taxing rights in respect of both. So in our submission, the court can properly be taken to have accepted that proposition and endorse the distinction between home states and host states, particularly given that its own conclusions are explicitly tied to the UK status as host state. So in light of the court's conclusion on objective comparability and justifications, the court declined to answer the question on proportionality, but that is something which the AG goes on to address. And in case it becomes relevant, it's worth a quick look here. So in paragraph 70, the AG says that even if a justification exists, the restriction of the freedom of establishment must not go beyond what is necessary to attain that objective. It must be stressed that in the present case, the examination of the necessity of the contested provision could not be based on the criteria laid down in M&S. That judgment relates to a situation in which a national provision serves to preserve the allocation of the power of taxation. So M&S was a case about foreign losses being used in the UK. So the UK's powers of taxation were in issue. The provision at issue in the present case does not serve that purpose, as has already been explained. If an autonomous justification for that provision were to be recognised in the form of the prevention of the double use of losses, the criteria for the necessity of such a provision must be adapted to that justification. So M&S, I don't think we need to turn it up, but it's behind tab 38 in volume 2. And what that case concerned, as I've said, is the use of losses incurred by non-resident subsidiaries of the Marks and Spencer group. So the freedom of establishment in issue in Marks and Spencer's was the freedom of a UK company to establish itself in another member state. So it was a home state case, and the losses in question were foreign losses, which M&S was looking to offset against UK profits. So there was no symmetry between the losses in question and the profits. Now, in a nutshell, what the court concluded was that the restriction on group relief was justified by a combination of the balanced allocation of taxing powers, the prevention of the double deduction of losses, and the risk of tax avoidance. But then the court went on to explain that the provisions went further than was necessary to attain those objectives in circumstances where there was no possibility of those foreign losses being deducted against any foreign profits in any period. Now, it's common ground that those M&S, the M&S criteria, the no possibilities test, is a very strict test, and essentially what it establishes is that it will only be in exceptional circumstances where there is no other possibility of the foreign losses being deducted elsewhere, that those losses are capable of being used in the UK. And what the AG is saying in paragraph 71 of Phillips is that in a situation like the present, where there's no issue with the balanced allocation of taxing rights, there is symmetry between profits and losses is maintained here because you're looking at the use of UK losses against UK profits. It's not appropriate to apply such a strict test as that which applied in M&S. A more generous approach is warranted in that case. And then in 73 to 75, she identifies 3 ways in which she says that section 403D1C is disproportionate. So first, she says it disallows all of the losses if only part of the losses are deductible overseas. Secondly, she says that it fails to differentiate between losses which are permanently deducted and losses which are only temporarily deducted because of the existence of a recapture mechanism like the Netherlands operates in this case. And thirdly, she says it's disproportionate because it precludes the deduction of losses for which there is merely a theoretical possibility of deducting them against foreign profits. And And then she concludes in 76, as a result of these multiple restrictions, I consider that section 403D1C is essentially geared to permitting group relief only where there is no provision in the member state of the foreign company for losses of a UK PE to be taken into account at all. The situation in the individual case is, by contrast, almost irrelevant. And so, accordingly, she thinks the provision goes beyond what's necessary to prevent the double use of losses. Now, just finishing off in the court's judgment on page 704, having concluded that the restriction was unjustified, the court moves on to consider the question of remedy, and in 38 it concludes that section 403D1C should be disapplied because it cannot be justified. And it's common ground that if the judgment in Phillips still stands, then that should be the outcome in this case. So then, moving on to NN, which is in volume 4, the judgment is behind tab 73. Now, at first blush, NN appears to be concerned with the same issue as Phillips, namely a restriction on the use of losses incurred by a resident PE of a non-resident company. However, on closer inspection, it can be seen that the situation with which NN was concerned was completely different to the situation at issue in Phillips, and that is because under Danish law, a Danish PE of a non-resident company and a Danish company was subject to the same restriction. And as a result of that, the freedom of establishment in issue in NN was not the freedom of a non-resident company to establish itself in Denmark. It was the freedom of a Danish company to establish itself in another member state. So NN, like M&S and Lidl, is a home state case, not a host state case. The difference between M&S and Lidl and NN is that whereas M&S and Lidl are concerned with foreign losses, NN is concerned with domestic losses. But all three are categories of home state case. So the relevant provisions of Danish law are set out in paragraphs 7 and 9 on page 905. And then in paragraphs 10 through to 14, the court sets out the factual background, which was rather exceptional in NN. So the losses in question had arisen when two Danish PEs of two Swedish subsidiaries of a Danish group were merged, and that event created a mismatch in the tax treatment under Danish and Swedish law. So for Danish tax purposes, that event gave rise to a loss in the enlarged Danish PE. For Swedish tax purposes, it was a non-event, so there was no loss. So the problem was, but the problem was in NN that notwithstanding the impossibility of deducting a loss which doesn't exist, the Danish provisions nonetheless precluded the deduction of that loss in Denmark. So picking it up at paragraph 18, the court
just
says,
to clarify, that was due to an election for tax-free treatment.
it was, yeah. Yeah. And similarly, I think there was also an election that the Danish group could have made for international taxation to bring the Swedish subsidiaries within, and it hadn't made that election. So that's why the mismatch arose. So in 18, the court says, in order for the law of a member state to constitute a barrier to the freedom of establishment of companies, it must result in a difference in treatment to the detriment of the companies exercising that freedom. That difference in treatment must relate to objectively comparable situations and must not be justified by an overriding reason in the public interest. So, in our submission, whether or not a provision amounts to a restriction on the freedom of establishment must be analysed at the level of the company exercising the freedom. So in Philips, the company exercising the freedom was a non-resident company in relation to which the UK was the host. That is not the situation in NN, as the court explains in the section headed difference in treatment. So in paragraphs 22, 25 and 26, the court there records, and in our submission can be taken to have accepted, the Danish government's submission that the difference of treatment at issue in Philips did not arise in NN because under Danish law, Danish companies were subject to an equivalent condition to that applicable to Danish PEs. And indeed, you can see from paragraph 27 that that proposition wasn't in dispute in NN because it was NN's submission that Danish law produced a difference in treatment of another nature. So in 28, NN explains that the losses of a permanent establishment situated in Denmark of a resident company in the group are deductible without restriction from the group's taxable profits in Denmark. In the case in the main proceedings, NN points out that if the Danish permanent establishment had been owned by one of its Danish subsidiaries, its losses could, in any event, have been set off against the group's profits. In that regard, it should be noted that the tax legislation at issue in the main proceedings does indeed establish such a difference. The tax treatment of a Danish group which owns a PE in Denmark through a non-resident subsidiary is under Danish law less favourable than that of a group in which all of the companies have their registered offices in Denmark. So the basis on which NN proceeded was that it was different to, not the same as, Philips. In NN, the comparison was between a Danish company with a non-resident subsidiary, which in turn had a Danish PE on the one hand, and on the other hand, a wholly Danish group.
I at some point put to this may just be a background point which is quite irrelevant, but it does seem to me at first blush anyway rather peculiar to have to envisage a situation where a company resident in member state A sets up a subsidiary abroad for the sole purpose of that subsidiary then establishing a permanent establishment back in country A again.
Well,
I mean, why on earth would any company want to do that instead of just setting up a domestic subsidiary or establishment of a branch?
Well, and this is really a point which the court makes later on, where it says essentially it would be ridiculous if a member state, a home state, was essentially required to confer an advantage on a resident company that's decided to set up a non-resident subsidiary and trade back into the home state through a PE. I mean, I think there are lots of situations in which that might happen. You might set up a subsidiary and that subsidiary's business evolves in such a way that then it wants to start operating back in the motherland.
Yeah, I mean, I can see it's a theoretical possibility, but I'm just puzzled as to whether these things really happen in the real world or whether this is just all dreamt up by accountants or lawyers trying to find a tax dodge.
Well, I don't think there's any
Put it rather
I don't understand there to be
unscientifically.
anything dodgy going on in Japan. I can see how, businesses evolve, don't they? And so you might start off in Denmark.
Well, they may.
And then you might want to expand your business in a particular direction which takes you to Sweden. And then 5 years later, that Swedish business has evolved and it actually comes back to Denmark.
Well, if those were the facts, I could quite understand it. But I mean, anyway, I don't think that we know enough about the facts to
No.
form a view. But I'm just, on the face of it, though, it does seem a peculiar thing to go about this roundabout circuit instead of just setting up the domestic subsidiary or domestic
Yeah,
branch.
I mean, what would be highly odd, I completely agree, is if you're a Danish company and you want to establish a Danish PE, and what you do is you establish yourself in Sweden and then you trade back into Denmark through a PE.
Yes.
And as I say, that is the reason why the court says Denmark is permitted to discriminate, because it would be absurd if in that situation the Danish company that's chosen to establish a non-resident subsidiary and trade back into Denmark were in a better position than a company that just simply establishes a Danish PE. So that's why that is exactly why the home state is permitted to discriminate.
And you say that if you start with the Swedish, so the equivalent host state analysis in NN is the Swedish company that's in the middle. Ignore the parent for the moment. The Swedish company is establishing in Denmark. So at that level, it's a host state.
And if that was the complaint, if the complaint was of the Swedish companies, if the Swedish company was saying, my freedom of establishment is in issue because I'm going to establish myself in Denmark, that complaint wouldn't have teeth, because Denmark turns around and says, well, what's your beef? If you establish as a Danish PE or a Danish subsidiary, you're treated in the same way because there's an equivalent condition. So there is no host state discrimination. The Swedish company doesn't have a complaint. The company that's got a complaint is the Danish company that establishes a subsidiary in Sweden. And that's why NN is a home state case.
Yes, it is quite difficult to see how the justifications fit with the almost happenstance of the difference in treatment that you say is critical.
Well, I would take issue with your use of the word happenstance. There's nothing happenstance about it. As the court has explained by reference to X in paragraph 18, you have to examine whether or not there is a restriction at the level of the company who's complaining, the level of the company who's saying, my freedom has been infringed. And as I say, in this case, the subsidiary is a Swedish subsidiary, but that Swedish subsidiary has no complaint. So you're comparing a wholly Danish group with a Danish group that has chosen to establish itself in another member state. So those are the circumstances. It happens to have established a subsidiary in Sweden. There are all sorts of reasons why it could have done that, but that's what it has done, and it is saying I am being treated differently.
But the difference ends up as a sort of as a sort of way in, rather than as being linked to the justification.
What do you mean? It's the way in.
Well, it gets you say it's critical.
Yeah.
It gets the case off the ground.
Yeah.
But the underlying policies and justification or otherwise are harder to link to that difference. Maybe you say they don't need to be linked in any way, except for one thing, which is to come back to the test for objective comparability. We're supposed to look at the purpose of the legislation. We touched on that
we
earlier.
do. But I mean, I think the key to unlocking NN is actually Beveler.
Yes.
And Beveler is really interesting because I think NN marks an evolution in the case law. It's not an evolution of Phillips, it's an evolution of M&S and Liddell and Beveler, which are all foreign losses cases. The novelty in NN is that it's a home state case concerned with domestic losses. And essentially, the same analysis applies because, well, we'll see how it's explained by the court in Beveler, but basically Beveler goes, the court and the AG say that in a situation where you've got foreign losses, the general rule is you can't deduct them, let's just say in the UK, because then you're deducting foreign losses against UK profits, no symmetry. But when you've got a case of definitive losses, final losses, there's no possibility of them being deducted anywhere else. In effect, in economic terms, those losses of a foreign PE are felt. They are a burden on the proprietor company. So if you're a UK company with a non-resident PE and your non-resident PE goes bust, it's made definitive losses, the entity that feels that loss economically is the proprietor company in the UK. So in effect, that, if you like, converts in very loose language what was a foreign loss into a UK loss. It's a loss that is felt in the UK, and that's the rationale for the M&S test. In those circumstances, you're effectively saying those foreign losses are equivalent to UK losses, and that's why you get the deduction in that exceptional circumstance. And in my submission, that is essentially what the court is doing in NN. It's saying, if you're a Danish company and you have a Danish subsidiary and a Danish PE, everything's in Denmark and taxing rights are all as you would expect. As soon as you establish yourself in Sweden, a Swedish subsidiary, Denmark loses taxing rights over that Swedish subsidiary. And if that Swedish subsidiary has a PE, let's forget for the minute that it's a Danish PE, but if it has a PE, those losses are essentially losses of the Swedish proprietor company. Now, if those Swedish losses, if the Swedish company, there's no possibility of deducting those losses in Sweden, in effect, those losses are felt economically back in Denmark. The Danish parent of the Swedish subsidiary with the PE is the entity that is feeling the economic burden of those losses. And in that exceptional circumstance, just like in Beveler and M&S, it's permissible to, or the home state should be required to allow those losses, or to put it another way, in that exceptional circumstance, the home state is not permitted to discriminate. And that's what's driving the analysis in M&S, Lidl, Beveler, NN. And that analysis does not apply in Philips because it is a host state case.
You effectively say NN deals with, well, as we've already discussed, a very rare set of facts where it's what you describe as home state indirectly investing in a PE back in the same state, and you say it's effectively restricted to that.
It is, yeah.
Situation.
Yeah, and I do accept that NN marks an evolution in the case law, but as I say, it's an evolution of those foreign losses cases.
But it's not it doesn't concern foreign.
Exactly, and that's why it's an evolution, because it concerns Danish losses. But it is applying the same reasoning because, as we'll see in a minute, the court applies Beveler by analogy. That's what it's accepting in NN, that it's not the same as Beveler, but it's saying that that reasoning applies by analogy. So I think I've already read 29 of NN, and then in 30 the court says that difference in treatment is liable to render less attractive the exercise of freedom of establishment through the creation of subsidiaries in other member states. It is, however, incompatible with the provisions of the treaty only if it concerns situations which are objectively comparable. So, again, we say, that the analysis in NN is very much tied into the particular difference of treatment to which the Danish provisions give rise, which is to make it less attractive for a Danish company to establish itself through a subsidiary in another member state. And we say that is the opposite of the situation at issue in Phillips. And because the court's reasoning here is so focused on the particular difference of treatment to which NN gives rise, because it proceeds on the assumption that the case is different from Phillips, that is why you see no further mention of Phillips. It wasn't relevant, and everybody understood that it wasn't relevant. So the next section of the judgment deals with the comparability of the situations. And in this regard, the court essentially applies by analogy the reasoning in Beveler. So can we turn that up, please? It's the judgment is behind tab 71, page 879 of bundle 4. And Beveler was another Danish case, but this time it concerned the Danish group taxation rules, which precluded the inclusion of profits and losses from non-resident PEs. So there are 2 points of distinction between NN and Beveler. Sorry, my lady, are you
Yes,
still?
sorry, I missed the reference. Could you just repeat it, please?
Bundle 4,
Bundle 4.
tab 71 is the judgment.
Thank you very much. Thank you.
So what we're looking at here is a Danish provision concerning group taxation rules under which profits and losses of non-resident PEs weren't to be included in the Danish group taxation provisions. So 2 points of distinction between NN and Beveler. The first is that Beveler is about cross-border losses. It's about losses incurred by a non-resident PE, whereas NN, as we've noted, is about domestic losses. And the second is that in Beveler, the difference of treatment restricted the freedom of a Danish company to establish a non-resident PE, whereas in NN, the difference of treatment restricted the freedom of a Danish company to establish a non-resident subsidiary. But nonetheless, regardless of that second distinction, both Beveler and NN are home state cases. So if we pick it up on 882, under the heading Preliminary Observations, in paragraph 18, the court observes there that allowing a company to deduct the losses of its PE in computing its profits constitutes a tax advantage. And then in paragraph 19 it says this: granting such an advantage where the losses are incurred by a permanent establishment situated in the member state of the resident company, but not where the losses are incurred by a permanent establishment in a member state other than that of the resident company, has the consequence that the tax situation of a resident company possessing a PE in another member state is less favourable than it would be if the PE were in the same member state as the resident company. By reason of that difference in treatment, a resident company could be discouraged from carrying on its business through a permanent establishment situated in another member state. So that's why this is what I'm calling a home state case, the right of a Danish company to establish a PE elsewhere. And then over the page on 884, the court addresses the comparability of those situations, namely the position of a resident company with a resident PE and a resident company with a non-resident PE. And then at 34, by little b, it says, where the legislature of a member state treats those two categories of establishments in the same way for the purposes of taxing their profits, it recognises that with regard to the detailed rules and conditions of that taxation, there is no objective difference between their situation which could justify a difference in treatment. And so that echoes the point which the AG makes in her opinion in Phillips, that by taxing the profits on UK activities of a UK PE in the same way as the activities of a UK company, the UK can be taken to recognise the comparability of those two establishments. And then the court goes on to say, at 35, by reference to the judgment in Nordia Bank and TMAC Agro, those judgments cannot be understood, however, as meaning that where the national tax legislation treats two situations differently, they cannot be regarded as comparable. So in other words, the opposite is not true. If the member state treats the rules treat the two the same, then they are recognising their objective comparability. If the member state treats them differently, that doesn't necessarily mean that they can't be regarded as comparable. And then it says at the bottom of 35, the comparability of the situations must be assessed with regard to the purpose of the national provisions at issue. And then in 37, it says, as regards measures laid down by a member state in order to prevent or mitigate the double taxation of a resident company's profits, companies which have a PE in another member state are not in principle in a comparable situation to that of companies possessing a resident PE. However, as regards losses attributable to a non-resident PE which has ceased activity and whose losses could not and no longer can be deducted from its taxable profits in the member state in which it carried on its activity, the situation of a resident company possessing such an establishment is not different from that of a resident company possessing a resident PE from the point of view of the objective of preventing double deduction of losses. So, whereas the position of a resident company with a non-resident PE and a resident company with a resident PE are not in principle comparable, they are in the exceptional circumstance where the non-resident PE has ceased operating and its losses are no longer deductible from any taxable profits in the non-resident member state. And that is because, as the court explains in 39, where a non-resident PE is wound up and its losses are no longer deductible against any non-resident profits, those losses become equivalent to the definitive losses of the resident company. And in that regard, they are equivalent to the resident losses sustained by a resident PE. And it's worth in this regard just turning up the AGO, which is in volume 3, behind tab 70. It's page 874. And so 58, the AG explains there that when a PE winds up its activities, in essence, the losses of that resident PE are then reflected or transferred directly to the proprietor company. And he explains in 59, that is the situation envisaged by the Marks and Spencer exception, the application of which is particularly justified when the definitive losses of a non-resident PE are identified as entailing for the proprietor company a reduction in its assets which is reflected in a reduction in its economic and therefore tax-paying capacity. Accordingly, in the case of definitive losses associated with the closure of a PE, the analysis of the objective comparability of the situations must not lose sight of that factor. The situation of a resident PE and that of a non-resident PE, both having definitive losses, are specifically for that reason comparable from the point of view of the principle of the tax-paying capacity of the parent company. In other words, those losses are felt, the burden of those losses is felt at the level of the resident company.
I'm sorry, I missed which paragraph you were reading from just then.
It was paragraph 59.
Thank you.
So returning then to NN, in paragraphs 34 and 35, so in 34 and 35, I'm in the wrong judgment, that's why. It is, we're back in tab 73. And
Page 908.
908, yeah, thank you. So in 34 and 35 there, the court considers by analogy with Beveler that a non-resident subsidiary with a resident PE is not in principle comparable to a resident subsidiary with a resident PE, except where there's no possibility of the losses incurred by the PE of the non-resident subsidiary being deducted against foreign profits. Now, importantly in our submission, neither Beveler nor NN say anything about the objective comparability of the situation at issue in Phillips, namely the difference of treatment between a resident PE of a non-resident company and a resident company. So the court then moves on to consider the justification, questions of justification and proportionality. And in 39 it says, the referring court asks whether that difference in treatment could be justified by the objective of ensuring a balanced distribution of power of taxation between the member states or by that of preventing the double deduction of losses. So just as in Phillips, the question and answer are tied to the particular difference of treatment at issue. And in our submission, the court in NN does not, and nor does it purport to, answer the question of whether the particular restriction that arose in Phillips was capable of justification or proportionate. Now in 40, the court rejects the balanced allocation of taxing powers, and then it moves on to consider double deduction of losses. And in 42, it observes that preventing the double use of losses has been recognised as a justification in M&S and Lidl. And then in 43 to 47, it accepts that if profits are taxable twice, then double deduction of losses would be justified, but says that's not going to be the case where the relevant double tax treaty gives double tax relief. And then in 48 it says this, the Danish law is specifically intended to prevent the group concerned from exploiting the same loss twice. In the absence of such a provision, as noted by the AG in point 75 of his opinion, cross-border situations would confer an unjustified advantage over comparable national situations in which a double deduction is not possible. The difference in treatment established by national legislation thus appears to be justified. So Denmark is permitted to discriminate against a Danish company with a non-resident subsidiary because if the position were otherwise, then a Danish company would be better off routing a Danish PE through a non-resident subsidiary, and that would obviously be an absurd result. So that is why Denmark is permitted to discriminate. And it's worth just noting that endorsement of the AG in paragraph 48, point 75 of the AGO, is the only point at which the court in NN endorses the AG. So we say in particular, the suggestion in another part of the AGO, paragraph 64, that perhaps the time has come to moderate Phillips in light of the OECD work on BEPS and the council directives on hybrid mismatches is not in our submission something which the court can properly be taken to have agreed with. It's apparent from the court's reasoning here that what it regards itself as doing is evolving the case law from Beveler, M&S and Lidl and applying that in the circumstances of NN. It doesn't draw on the OECD's work or those council directives in support of its proposition. So, having found that the Danish provision gave rise to a limited but justified restriction on the freedom of a Danish company to establish itself in another member state, the court then goes on to consider the question of proportionality. And again, it's important to note that the analysis is tied to the particular situation at issue in NN. So in 49, the court says that difference in treatment must still be proportionate to its objectives, to its objective. And then the court goes on to explain in 52 to 54 the reason why the Danish provision is disproportionate, which is that since losses incurred by a Danish PE of a Swedish subsidiary are in principle deductible in Sweden, the Danish law precludes their deduction in Denmark. And then the court says this at 55. If the setting off against the Danish group's profits of the loss sustained by the resident PE of its non-resident subsidiary were accepted by derogation from the rule laid down in Danish law, since the group would have demonstrated that the setting off of the above-mentioned losses against the subsidiary's profits is actually impossible in the other member state, there would be no question of disproportionality. So in our submission, NN is authority for the proposition that a member state is in principle entitled to discriminate as between a resident subsidiary and a non-resident subsidiary as far as the deduction of losses is concerned, except in the exceptional circumstance where there is no possibility of the non-resident subsidiary deducting the losses against foreign profits. And we say that if the reasoning of the court in Beveler is applied by analogy to the situation in NN, the reason why that should be is because if there is no possibility of the losses being deducted by the non-resident subsidiary, then economically the burden of those losses is experienced at the level of the Danish parent company. And so the two situations are comparable. So we say NN is not concerned with and therefore says nothing about the entitlement of a host state to discriminate between a non-resident company with a resident PE and a resident company, which was the situation in Philips, and for which Philips remains the definitive authority. So turning then to the specific issues, issue 1, whether NN overruled Philips on the question of justification. In our submission, plainly it did not. Each of those cases is explicitly concerned with the particular difference of treatment to which the specific national provisions gave issue. And indeed, in NN, the court proceeds on the understanding that the situation at issue in NN is different to that at issue in Philips. Now, the Upper Tribunal's decision on this point is set out in 64 to 75 of its decision, and it can be summarised as follows. Firstly, the Upper Tribunal says that sometimes the CJEU acknowledges when it is moving on from reasoning in a previous case, and sometimes it doesn't. It's paragraph 70. Secondly, the Upper Tribunal says the question of whether the double deduction of losses is a sufficiently good reason for infringing the freedom of establishment involves a value judgment, and the outcome will vary depending on the times. That's paragraph 72. Thirdly, it says that the recent council directives, which have been implemented to regulate, amongst other things, the double deduction of PE losses, is illuminating. That's again paragraph 72. And then fourthly, it says Philips cannot be distinguished from NN on the ground that it concerned host state rather than home state discrimination. So taking those points in turn, it's not in dispute in this case, and we are content to accept that sometimes the CJEU does depart from its previous decisions without expressly acknowledging that that is what it is doing. And a good example of that is the Adui case, which is behind tab 31 in volume 1. I'll just turn that up quickly. It's page 155. Now, in Adui, the question was whether the Belgian authorities were entitled on public policy grounds to refuse to issue a certificate of residence to 2 French nationals on account of their employment in a bar, which was said to be suspect from the point of view of morals. But in circumstances where the Belgian law imposed no legal sanctions on people who chose to work in such establishments. Now, in a previous case, Van Dyne, which we don't need to turn up, but it's, if you'll note, it's behind tab 27, the court held that a member state was entitled to discriminate between its own nationals and nationals of another member state on public policy grounds, where the member state considered that an organisation, in that case it was the Church of Scientology, where it considered that the organisation with which the individual was concerned was socially harmful, even though that association was not unlawful in the member state. Now, Van Dyne was then subsequently clarified by the court in a case called Bouchereau. Again, we don't need to turn it up, but it's behind tab 29. And in Bouchereau, the court explained that the concept of public policy presupposes a genuine and sufficiently serious threat to the requirements of public policy affecting fundamental interests of society. So that was the state of the law when the Adui case came before the court, and we can pick it up in paragraph 8 on page 194.
Sorry, is it 194?
194. It's 1707 internal of the report and 194 of volume 1. Should be a page headed the concept of public policy. Is there a mismatch between the...
I think there might be this.
Another mismatch.
Is this the head under the heading the concept of public policy?
Exactly, yes. Yeah.
Questions 1
Yeah.
to 9. Then.
Yeah, you got it. So in paragraph 8, the court said it should be noted in that regard that reliance by national authority upon the concept of public policy presupposes, as the court held in its judgment of Bouchereau, the existence of a genuine and sufficiently serious threat affecting one of the fundamental interests of society. Although community law does not impose upon the member states a uniform scale of values as regards the assessment of conduct which may be considered as contrary to public policy, it should nevertheless be stated that conduct may not be considered as being of a sufficiently serious nature to justify restrictions on the admission to or residence within the territory of a member state of another member state in a case where the former member state does not adopt, with respect to the same conduct on the part of its own nationals, repressive measures or other genuine and effective measures intended to combat such conduct. Now, in our submission, when the court concluded that the Belgian authorities were not entitled to discriminate on grounds of conduct which was not subject to legal sanctions within that member state, it can only have been departing from Van Dyne. There is no other reading of a DUI which is compatible with the decision in Van Dyne. So in our submission, whilst the Upper Tribunal was right to regard a DUI as an example of the Court of Justice departing from the previous decision without expressly saying so, it is not analogous to the present case, where in our submission there is a perfectly reasonable reading of NN. Indeed, we say the right reading of NN, which is consistent with the decision in Phillips. And that is because NN and Phillips are concerned with different situations. So we say that a DUI is not a good example on which to justify a conclusion that NN can properly be taken to have departed from Phillips. And furthermore, it remains the fact that it is rare for the court to depart from its previous decisions without expressly saying so. And indeed, the court will only depart from its previous decisions if there are compelling reasons for it to do so. And this is a point made by Advocate General Fennelly in the Merck case, which is at the back of volume 1. And if we can just briefly turn that up, page 257, it's paragraph, top of paragraph 142 of his opinion here. He says it is nonetheless obvious that the court should, as a matter of practice, follow its previous case law, except where there are strong reasons for not doing so. Now, in the present case, we say there were not strong reasons for the court in NN to depart from its decision in Phillips, because it was looking at and analysing a totally different situation. There was no need for the court in NN to depart from Phillips.
Does the court ever expressly acknowledge it is departing from its previous learning? And I've offhand, I can't think of any case where I've seen that. Although we all know it does sometimes.
Oh, well, we had these below, actually. There are instances, there are lots of instances.
Well, I'm sure I'm very happy to take it from you if you say that there are, but my impression is, you know, they never... and partly, of course, because they don't have a doctrine of precedent in the sense which we understand it. So you're normally just left with a kind of process of criminology, one might almost call it sometimes.
Yeah, I think actually Merck is an example, actually, of it saying so. I'll try and find the reference.
Okay, so I don't want to
over the lunch break.
Take you out of your
there are examples, but it's as the Advocate General says in Merck that the general practice is to follow it if it can, and
does it partly depend on what you mean by depart?
Yes.
Yes, I mean, I suppose if you're
Because
evolving
you could
the
take
case,
a strict view of, you say, well, I'm not departing from this case because it's on different facts, and it decides, the narrow point it decides on those facts is different from the point which is at issue in this case. But I think the argument against you is that the principles about double use of losses, the idea that double use of losses could be a justification, gets very brisk treatment in Phillips, and you could say, well, the reasoning about the underlying principles in NN is just poles apart from what's said in
yeah, I mean,
NN.
yes.
So that's why I say, does it depend on what you mean by depart? I haven't put that at all crisply.
I think you're making the same point as me, which is that there's in NN the court is looking at a different situation, therefore there's no reason for it to expressly say we're departing from Phillips, but the question is whether it should be taken to have done so by implication. If you like.
Yeah. And on any view, to state the obvious, I mean, NN is the later case, and it so happens had the same juge rapporteur as Phillips. I mean, so
had the same
juge
right,
rapporteur, yes. So
yeah.
there can't be any question of Phillips having gone by default, as it were, and indeed there was references to it in the question.
Oh, everybody was aware of
and so on.
Phillips,
So everybody was well aware of Phillips.
Yeah.
But now we have an entirely different perspective taken by both the AG and the court on the question of
well, not an
justification.
entirely different perspective.
Well,
as I say, what the court in NN is doing is no doubt it is an evolution of a line of cases, but it is an evolution of the home state analysis, which had hitherto applied only to in cases of foreign losses. And as the AG says in Phillips, the one time it had come before the court on domestic losses case, the Papillon case, the court said it's not in play, and that's what's that's what NN does. It applies that foreign losses analysis to a home state case concerning domestic losses. And in our submission, you cannot extrapolate from that what the court was doing in Phillips was also overruling the decision in Phillips, which was concerned with host state discrimination and the use of UK losses in a situation where there is no asymmetry. So there's good reason for the distinction, and it is explained by the AG, and we say by the court in Phillips, for the distinction. A host state has taxing rights, so the general rule is it's not allowed to discriminate. That's not the case with the home state. So in 74.3, paragraph 74.3 of the Upper Tribunal's decision, it suggests that if the Court of Justice in NN had considered its decision to be consistent with Phillips, then it would have said so. Now, in our submission, and with respect to the Upper Tribunal, that reasoning is completely illogical because in the first instance, as we've said, there's no reason for the court in NN to agree with the decision in Phillips when it proceeds on the understanding that it's addressing a different situation. But secondly, if the Upper Tribunal was essentially prepared to accept that the court had departed from Phillips without saying so, why should it expect the court to have said so if it agreed with Phillips? It makes no sense. In our submission, the most reasonable inference from the court's silence either way on the decision in Phillips is that the court did not consider it to be in point. For that reason, it said nothing more about it. So the second reason of the Upper Tribunal's reasons, namely the question of whether double deduction of losses can be a justification for discrimination is a value judgment which will vary with the times. We say this, that even if that is right, it's not a value judgment for the Upper Tribunal to make. The court in Phillips has made that value judgment in the context of the very provision at issue, and it has said in terms that a host state, such as the UK, cannot rely on the double deduction of losses to justify discrimination against a non-resident company when the losses in question are linked to the host state's right to tax. Now, in our submission, nothing in NN can be taken to have indicated that a different value judgment on that question should now be made in the context of host state discrimination. The rationale for the value judgment in NN, as the court explains, is that if the position were otherwise, the reason why double deduction is a legitimate justification for a home state discriminating against a resident company with a non-resident subsidiary is that if the position were otherwise, then the home state would essentially be required to confer preferential treatment on a resident company that has chosen to establish itself and take itself out of the fiscal jurisdiction of the home state. And that cannot be right. So we say that NN involves a different value judgment that doesn't necessarily apply in the case of a host state. And Phillips makes the value judgment in this very situation. And even if the Upper Tribunal would itself have made a different value judgment, that's not the Upper Tribunal's function. It's not its call to make. Phillips is binding on the Upper Tribunal, and it's binding on this court unless you exercise your powers under Section 6. So the third reason which the Upper Tribunal gives is that it says things have evidently moved on, and it relies in particular on the recent council directives which have been implemented to regulate, amongst other things, double deduction of PE losses. And if we can briefly turn those up, they're in volume 1, behind tabs 6 and 7. You can just pick it up in tab 7, page 27. So you can see from the recitals that the genesis of the directive is the OECD initiative on BEPS, and you can see there in recital 4 that one intended, or the intended target is hybrid mismatches, and in 5 says it's necessary to establish rules that neutralise hybrid mismatches. And then over the page 32, hybrid mismatches is defined just beneath the first hole punch. Hybrid mismatch means a situation involving a taxpayer where...
Sorry, which paragraph?
It is... I've lost track of what it is, but it's Article 1, 2...
No, just the
9.
paragraph.
It says 9 by the side of it.
Yes,
Hybrid
thank you.
mismatch means a situation involving a taxpayer where, and then it's right at the bottom G, a double deduction outcome occurs. And then over the page, in between the two hole punches,
Sorry, again, what page are you on?
33. You'll see it's the second paragraph. It says, for the purposes of this point 9 and articles 9, 9A and 9B, and then it's B, do you have that double deduction? Double deduction means a deduction of the same payment, expenses or losses in the jurisdiction in which the payment has its source, the expenses are incurred, or the losses are suffered, payer jurisdiction, and in another jurisdiction, investor jurisdiction. And then over the page, page 34, towards the bottom of the page, there's a heading hybrid mismatches. And it says, to the extent that a hybrid mismatch results in a double deduction, A, the deduction shall be denied in the member state that is the investor jurisdiction, and B, where the deduction is not denied in the investor jurisdiction, the deduction shall be denied in the member state member state that is the payer jurisdiction. So the primary rule, if you like, is that UK losses should be deducted against UK profits. So the Netherlands should deny the deduction. But in the event that the Netherlands drops the ball, as I put it, the UK should step in and deny the deduction. Now, we make 2 points about these council directives. First and foremost, nothing in these directives supports the proposition that in combating hybrid mismatches, a host member state is entitled to discriminate as between resident and non-resident companies. So there's a suggestion in the revenue skeleton that section 403D 1C should be regarded as ahead of its time. But in our submission, the problem with section 403D 1C is that it's not matched by an equivalent provision for UK companies. So whilst, yes, the directives mandate the prevention of double deduction of losses, they don't suggest that in achieving that objective, member states are entitled to adopt whatever measures they deem necessary. So for that reason, we say the directives only take us so far. They demonstrate that preventing a double deduction of losses is a legitimate objective. However, the question at issue in this case, as it was in Phillips, is whether that objective can be used as a justification for host state discrimination. And on that question, nothing in the directives suggests that it can. And the second point we make about the directives, which is over the page on page 36, under Article 2, you can see that the provisions in the directives apply from 1st of January 2020. So, to the extent that the directives can properly be regarded as signalling a change of approach to the question of double deduction, preventing the double deduction of losses, and even if they can properly be regarded as signalling that change in relation to a case of host state discrimination, they certainly can't be taken to have effected any such change on a retrospective basis. And for that reason, even the AG and NN accepts that it would not be appropriate to apply the directives in the circumstances of NN, which, like the present one, concerned an accounting period ending in 2008. And as I've already said, as far as the court's reasoning in NN is concerned, it was very much rooted in the existing case law, Beveler, Marks and Spencer, Liddell. It makes no mention whatsoever of the recent council directives. So in our submission, the directives are not a proper basis on which to infer that the court has moved on from its conclusion in Phillips. Namely, that in the case of a host state, the double deduction of losses is not a justification for discrimination against a non-resident company. And then the fourth reason why the Upper Tribunal concluded that NN should be taken to have overruled Phillips is essentially because it rejected as relevant the distinction between host state and home state discrimination. And in our submission, it is obvious from the face of the decision in Phillips that the UK's position as host state was central to the analysis. I've shown you the repeated references to host state. So in our submission, it is fanciful to suggest that the court did not regard the UK's status as host state as highly material to its analysis. Now, it is true that in NN, the court's conclusions were not expressed by reference to Denmark's status as home state, but in our submission, that is the only implication. The case proceeded on the understanding that the restriction in issue was of another nature, namely one which infringed the freedom of a resident company to establish itself in another member state. That is home state discrimination by another description. And with further respect to the Upper Tribunal, its observation that the categories of host state and home state discrimination are not mutually exclusive, and that Phillips is in fact an example of both, is nothing to the point. The point is that the complaint in Phillips was one of host state discrimination. The company who was complaining of the infringement was a non-resident company. And as the court points out in NN, by reference to X holding, whether or not the provision gives rise to an unjustified infringement of the freedom of establishment must be analysed at the level of the company complaining.
Do you have a paragraph number for that?
19, I think it was. 18 or 19. I think it was 18, actually. 18 of NN. So in our submission, whether or not section 403D1C might also be said to give rise to home state discrimination is irrelevant. The freedom in issue was the freedom of a non-resident company to establish itself in the UK, not the freedom of a UK company to establish itself in another member state. And finally on this point, the Upper Tribunal concluded that there was no good reason for the distinction between home state and host state, but with respect to the Upper Tribunal, the reason for the distinction is articulated at length by the AG in Phillips, paragraphs 49 et sec, which are endorsed by the court in paragraph 31. The reason for the distinction is that as far as the host state is concerned, the double deduction of losses has no impact on its taxing rights. If you allow the UK losses to be deducted in the Netherlands, it has no impact on the UK's right to tax UK profits. It has no impact on the proper deduction of UK losses against UK profits. So regardless of that, their utilisation in the Netherlands, the losses in question remain linked to the UK's taxing rights, and that is what the court acknowledges, regardless of their deduction in the Netherlands. So that is why a host state cannot rely on that justification, by contrast with a home state that doesn't enjoy taxing rights, and that is why a home state is permitted to discriminate save in exceptional circumstances. So that was all I wanted to say on issue 1. I can deal with the next 2 issues more quickly. Issue 2, whether section 403D1C is disproportionate. So the Upper Tribunal addresses this in paragraphs 76 to 81 of its decision, and in summary it concludes that 403D1C is disproportionate in 2 respects. First, by precluding the deduction of all losses if only part are deductible against foreign profits, and secondly, by precluding the deduction of losses which are in principle deductible, or in theory deductible, even if there is no practical possibility of those losses being deducted. Now, in our submission, if Section 403D1C is capable of being justified by reference to the objective of preventing the double deduction of losses, then it is also disproportionate in another respect, namely in its failure to differentiate between losses which are only temporarily deducted and losses which are permanently deducted. And that is the point which the AG makes in paragraph 74 of her opinion. So, under Dutch law, although the losses incurred by the UKPE were deductible by the Dutch company, they were subject to a recapture mechanism whereby the deduction of those losses in the Netherlands was essentially reversed out by bringing any subsequent UK profits within the tax charge in the Netherlands. So that's how the recapture mechanism operated. So in essence, it reversed out that deduction. So at the point of deduction in the Netherlands, by virtue of the existence of the recapture mechanism, the deduction is only temporary. Now, in our submission, in a case such as this, where the losses in question are linked to the UK's taxing rights, there is no necessary or obvious reason why the M&S criteria should be taken to apply. Now, in cases of home state discrimination, it is readily understandable that the ability to use foreign losses in the home state should be reserved to exceptional circumstances where there is no possibility of those foreign losses being deducted elsewhere. And that is because, as I've said, the economic burden of those foreign losses is essentially experienced at the level of the resident company in that exceptional circumstance. But in a host state case, where the member state is in a materially different position regarding its taxing rights, and where on any view the more appropriate place for those losses to be taken account of is in that member state, in our submission, the host member state should only be permitted to deny the deduction in exceptional circumstances where the losses have been permanently deducted against foreign profits. In other words, where there is no possibility of the losses being recaptured. And that is essentially what the AG encapsulated in paragraph 71 of her opinion in Phillips. Because a home state doesn't enjoy taxing rights, it is in general permitted to discriminate, save in those exceptional circumstances. By contrast, a host state which does enjoy taxing rights is not generally permitted to discriminate, save in those exceptional circumstances where there is no possibility of the losses being recaptured overseas. So that is the reason why the M&S criteria require modification in a case like this, because they are targeting a different circumstance. In other words, in a home state case, they are targeting the situation, or they are identifying the situation in which it is not okay for a home state to discriminate. In this scenario, the criteria are targeting a different situation. They are trying to identify when it they're trying to identify the situation where there is no possibility of the losses being recaptured. In other words, where they have been definitively deducted in the Netherlands. So in that situation, a host state is permitted to discriminate. So that's the modification that's required to the M&S criteria. However, we say in line with the M&S test.
So it's really the opposite.
It's the opposite, yes. Which reflects the UK status as host state. So that's how we say the criteria should be modified, but we say that in line with the M&S test, the no possibility of recapture test should be taken to apply only in circumstances where there is no real possibility of the losses being recaptured. In other words, where there are no legal possibilities available in the company's state of residence for the losses to be recaptured. In essence, because the company has been put into liquidation.
So just to clarify, on the facts here, you say it is still legally possible, even though the company in question is dormant.
Exactly. Because when the shoe is on the other foot and you're looking at it, you're looking at the no possibilities test in relation to whether there's a possibility of the losses being used. That's how the court has approached it. If there is a legal possibility, then you cannot satisfy the test. Essentially, the company has to be put into liquidation. The non-resident company has to be put into liquidation before you say there's no possibility of those losses being used. And so this is the point that Mr. Justice Park makes in Marks and Spencer, is there is a difference between a possibility and a likelihood. And the no possibilities test is not concerned with how likely or otherwise it is that situation arises. It's concerned with the possibility. And we say that same approach should be applied to our modified criteria. So in our submission, section 403D1C must also be regarded as disproportionate to the extent that it precludes the group relief of losses which have been temporarily deducted against non-UK profits, unless there is no possibility of those losses being recaptured. And so then issue 3 is whether section 403D1C can be subjected to a conforming interpretation under which it is proportionate. The Upper Tribunal addresses this in 82 to 93 of its decision. And in summary, it concludes that it is possible to apply a conforming interpretation to section 403D1C. And it says that it should be read in such a way as to ensure that only losses which have actually been deducted from or allowed against non-UK profits are disqualified. Now, as an aside, there appears to be, or certainly there appears to me to be, some internal inconsistency between the conforming interpretation which the Upper Tribunal proposes in 92 of its decision and its reasoning in paragraph 77. So in paragraph 77, the Upper Tribunal there appears to suggest that 403D1C would be proportionate if it permitted the deduction of losses where there was no possibility of their deduction overseas. And that's, of course, how the revenue say 403D1C should be interpreted. So it's by reference there to the M&S no possibilities test that they think it would be proportionate. It's looking at real possibilities. But then in 92, it formulates its conforming interpretation by reference to actual deductions rather than mere possibilities. So there is a degree of tension, certainly to us, in those two paragraphs, which does not appear to have been resolved. But in any event, an interpretation along either of those lines, we say, would be flawed.
Sorry, is that tension to which you refer of any practical impact?
Not as far as I'm concerned, no. I say that if you're to take a 77 approach, it's still flawed. We say the outcome is the same. So for the reasons I've just submitted, the flaw in 77 is that it fails to differentiate between temporary and permanent deduction. So it's applying the M&S test without modification, which I say does not address the totality of the disproportionality in 403D1C. And then as far as the interpretation in paragraph 92 is concerned, we say that that interpretation is not permissible because it goes against the grain of the legislation. So
just to clarify, both parties appear to accept that the effect of what the Upper Tribunal concluded at 92 was that on the facts of this case, the losses were confined, the available losses were confined to those
which have
been recaptured.
Correct, yeah.
So that is, unless I'm missing something, construing deducted or allowed as taking account of that recapture.
Yes, so it's, I suppose it's saying it's looking to when you're not assessing deducted by reference to just the simple act of deduction. You're looking for a permanent deduction. It's really an aside. I mean, you know, as I read back over the decision, I struggle to reconcile.
Okay, but I'm at a really practical level. Both parties accept that the effect of the Upper Tribunal decision
that's
is
agreed.
You get a limited allowance of losses by reference to the amount that was recaptured.
Yes.
So both parties are construing the Upper Tribunal's finding as a giving rise to that conclusion. It's just I wanted to clarify because it's not jumping off.
No, you're absolutely right. I'm sorry to set a hair running, but it just I didn't want to it was something that occurred to me, and I didn't want to not draw it to your attention that there is that there is that internal inconsistency, but it doesn't. At the end of the day, you're right. The conforming interpretation which the Upper Tribunal picks is one by reference to actual deduction and not recaptured.
Yes.
Yeah. Well, strictly, it left that bit to the parties, but that's how the parties understood it. So yes, that is agreed.
Well, so you both agree that's to be inferred?
Yes. Well, essentially, yes. So, as to the conforming interpretation which the Upper Tribunal sets out in 92, we say it goes against the grain of the legislation. And at 84 of the Upper Tribunal's decision, it sets out a passage from the judgment of Sir Andrew Morritt in Vodafone 2, which says any conforming interpretations go with the grain of the legislation. An interpretation should not be adopted which is inconsistent with a fundamental or cardinal feature of the legislation, since this would cross the boundary between interpretation and amendment. Now, in our submission, the fundamental or cardinal feature of section 403D1C is, as the AG in Phillips observes in 76 of her opinion, and as the UK itself observes in its response to the Commission, that it is concerned with legal possibilities for deduction. It's a no possibilities test. And we say that is the grain of the legislation. In our submission, a provision which is concerned with actual deduction of losses is a fundamentally different provision, and one which cannot be introduced by way of interpretation. So we say the error in the Upper Tribunal's decision is that it examines the grain of the legislation at too high a level of generality. So in paragraph 91, the Upper Tribunal describes the essential feature of the legislation as being that group relief should be restricted where other relief is available for the same loss.
Sorry, 91
of the Upper Tribunal's decision. So towards the bottom of the second half of that paragraph, it says, however, the proposed interpretation retains the essential feature of section 403D1C, namely, that UK group relief should be restricted where other relief is available for the same loss. And we say that framing the grain of the legislation in that way is to view it at too high a level of generality.
So it all depends on whether you're looking at the grain with a microscope or standing back and just looking at the general pattern.
Yes, exactly. So, and we say that the grain is identified by the AG in Phillips and by the UK itself, which is that it is a test concerned with possibilities of use rather than with actual deduction of such losses. So that's why we say it goes against the grain. In the alternative, we say that even if 403D1C is in principle susceptible to a conforming interpretation along those lines, the words deductible and allowable must be construed as meaning definitively deducted and definitively allowed, in the sense that there is no real possibility of the losses being recaptured.
You mean no legal possibility?
Yes.
So as per your earlier submission?
Exactly, yes.
And on that basis, you would say that you're entitled to all the losses. In other words, on the facts of this case, no restriction.
Yes. So that was all I was going to say by way of opening, unless you have any further questions.
No? No? Well, we've got another few minutes, so shall we start, please, Monsieur, see where we get to?
Yeah. We're going at a good pace so far. So the idea is that I will now reply on the taxpayer's appeal. What I was proposing to do was to combine that with the revenues cross-appeal on proportionality, which obviously go together. And then after dealing with that, I will turn to our cross-appeal on objective comparability. It won't surprise you to learn that I take issue with many of the things that my friends said so far this morning. So, can I summarise our submissions before I turn to the case law on justification? The first submission is that a restriction on the freedom of establishment can be justified by the aim of preventing the double use of losses alone, and that includes the use of the same losses in two jurisdictions. My second submission is that this is so even where the situation is not one in which there is any threat to the balanced allocation of taxing rights. And I say in parenthesis, in deciding otherwise, Phillips was an outlier as regards the line of authority in the European Court of Justice. We say NN departed from Phillips in Phillips' interpretation of the treaty in that respect. And it is important to remember that the Court of Justice, its only jurisdiction is to to interpret the treaty, not to decide the case before it. It has been suggested that there is some significance in the fact that Phillips was a case about which concerned a reference from the UK on these UK provisions. We say that could have some significance, but it has no significance when you are looking at the European Court talking at a level of generality about the interpretation of the treaty, and we say that's what happened in NN. My third submission is that this approach reflects international tax policy, which underlines the BEPS, which you'll see in the base erosion and profit shifting initiative, and also as a product of that, one product of that, the EU directive, which was you've been taken to 2016-1164. So then my fourth submission is it is proportionate to deny relief if the losses in question can be used in the other state, brackets whether they are or not, and we say this is consistent with the case law of the Court of Justice on the Marks and Spencer's no possibilities test, which we say is the appropriate test to be applied, rather than the reverse Marks and Spencer's test suggested by my learned friend. And fifthly, as an alternative, and this is endorsing what the Upper Tribunal decided, a proportionate result would be to deny relief to the extent the losses are actually used in the other state, or actually deducted. And we have agreed, we are in agreement that if that were the test, in other words, the Upper Tribunal's conforming interpretation were correct, then that would apply to a situation in which the losses are deducted but then recaptured, so that it would only be the net amount.
So in other words, the result would be as per the Upper Tribunal's decision.
Yeah. That, as my other friend said, that's reflected in the agreement after the judgment that the parties came to.
Okay, so but your cross appeal would lead to a full.
Our cross appeal on proportionality would lead to the whole of all of the losses being not allowable.
On proportionality.
Our cross appeal on proportionality.
Okay, all right. I hadn't quite grasped that. I thought that was the case with objective comparability.
That is the case with objective comparability, because that just ends the case at that point. But it's also the case on proportionality, because I think this may be common ground that if you do apply the Marks and Spencer's approach, which we say is what the court did in NN, then the result in this case would be that there is a possibility of using the losses. In fact, they have been used.
I see.
So that's the point of our cross appeal. It's not purely an academic exercise.
Okay, and just to clarify, I mean, obviously on the face of it, the amounts involved in your cross appeal are I use the term advisedly, limited, but presumably it's of wider relevance.
It has some wider relevance, but anyway, I guess we're here, so.
Yeah. I just wanted to understand the significance of the cross appeal.
Yes.
Because on the numbers, by reference to the entirety of the losses, it's a small proportion.
It may be that if there was no appeal, there'd be no cross appeal. Put it that way.
Okay.
But I understand. I think the instructions are that there is at least one other case coming behind. Maybe.
There usually is, so I just wanted to clarify.
And this is the kind of case where we're concerned with historic losses because of the changes in legislation, both European and domestic, which have taken place since the 15 years ago when these,
Yes.
that the
Yes.
accounting periods are concerned with. Is that right?
Although I think it's gone back. I mean, I think my learned friend showed you the change in 2013.
Yes.
But actually, if you notice carefully, it said 2013 to 2016, and actually, it has gone back to what it was.
Well, as I understand it, as from 2021, it's gone back to this.
Yes, exactly.
This sort of wording.
Exactly. Yeah.
Following EU exit.
Yeah. So it may be relevant or not in the future. Who knows? I don't think I don't think anyone's quite worked out exactly what the Withdrawal Act means.
Might that be a convenient
Yes, it might be.
We can ponder that question over lunch. Should we say 2 o'clock, please?
All right.